Everly?
Mr. Packham, may I remind you, you are still under oath?
I'm sorry, I'm going to have to adjourn. Oh, yeah, sorry.
Jesus. Ready? Mr. Packham, I intended to leave the following for argument, but maybe in fairness to you, I should put it to you. I've indicated that I had no further questions. The court reminded me that I had the tea time to think about it, so I'm afforded an opportunity to continue my cross-examination. And in fairness to you, maybe I should put to you and give you an opportunity to comment on what I would have left for argument. If one has regard to your narrative of the events, Mr. Packham, that would necessitate the court following the following, or accepting the following scenario. That the real culprit who attacked or hijacked your wife did so around about 7 o'clock in the morning. He stayed in the area where he committed his crime for at least half an hour, because that's when he's seen driving away. He, in the execution of his crime, he goes so far as to kill your wife and put her in the boot of her car. Then he drives around in the same vicinity of the scene where he committed his crime, apparently not scared of being pulled over or stopped because of the number plates of the vehicle being missing. Or, one needs to speculate further, he could have left and then come back, but that would in all probability be even worse. Because the vehicle is seen at 2 o'clock in the afternoon. Then one must presume again that he remains in the same area, or again left, but for some reason comes back to the same area. And then he goes, and the prize for which he presumably committed this attack, this hijack, the motor vehicle, is set alight. And not just set alight, but the doors are locked before he abandons it and sets it alight. Would you like to comment on the probability of such a scenario happening, sir?
Milady, I guess it's one possibility.
So you are of the view that it is a possibility that somebody could act like that, having committed a hijacking?
I'm afraid I don't know, milady.
That is in actual fact the inference that the court needs to draw on your version of the events, the version that you want to be out there, that you've now testified to for the last almost 3 days.
I did not put that scenario, milady. I don't know what happened. I honestly don't know.
That's your comment.
Yes.
And you do not want to speculate?
I can't. No, I don't.
Mr. Packham, I'm going to argue that having heard your side of the story, and when considering that with the evidence presented by the state, that somewhere in between you and your wife arriving home on the 21st of February 2018 and the morning of the 22nd of February 2018, you hit your wife with an unknown object, probably first on the jaw, a blow which incapacitated her, You then struck her a second blow over the side, more towards the back of her head, which killed her. And not that motive is an element of a crime of murder, but in all probability you found yourself in a tight spot due to your long-running affair with witness X and your wife's apparent still upsetness about your continuous disclosures about your infidelity. Sorry. You might even, as it was suggested, the possibility to Dr. Friedling, have attacked her when she was already in the car on the way to school. Having handled the murder weapon, the blood droplets in the garage would have very well come from your own hands and or the murder weapon. You also proceeded then to remove your wife from the passenger part of the vehicle and put her in the boot of her own vehicle, explaining the blood on the garage frame, which would incidentally fit with Dr. Friedling's opinion of that being the reason for the second injury post-mortem to the head of your wife. And you having handled the murder weapon, that explains how the blood ended up on the inside of your vehicle's right-hand door handle. That explains why you never reported your wife missing, contrary to what you want the court to believe. And you also didn't want help to look for her, because you knew all along where she was. You also knew where the car was. You were driving around in that car in the vicinity of your home. And probably, after realizing that you'd now been noticed by Mr. Gray, you went and you left the car at Deep River Railway Station and locked it. And wherever you were driving around, either with your wife's car or with your own, is simply because you were trying to find a place to get rid of evidence. The murder weapon, your wife's cell phone, the handbag, the number plates of her vehicle. And eventually, after having spent the evening with your sister, having dinner, discussing what should be done to search for your wife, around about 9:30 that evening, you simply set the car alight at the location where you probably left it earlier that day, thinking that the fire would destroy any and all evidence remaining in the vehicle, and your wife would simply become another statistic of hijacking. And that would explain, Mr. Packham, why that evening, when Sergeant Sonnenberg called you to interview you about the body having been found in the vehicle and your wife's disappearance, you were too tired, too exhausted. That will also explain why the next morning you were totally disinterested to attend the meeting at a time when it was favorable to you. In effect, Mr. Packham, I'm going to argue that you killed your wife and set the vehicle alight. Would you like to comment on that?
My lady, I categorically deny what the prosecutor has just said.
I have no further questions for the witness, Madam.
Yes, Mr. Webster.
Thank you, my lady. We have no re-examination.
Mr. Packham, there are a couple of questions I want to ask you. Basically to clear up some questions that I have myself. When your wife left home, you were still there,
Correct,
7 o'clock
my lady.
that morning. And you stayed there until around about 8:30.
I believe, no, 7:30.
7:30. And
That's
you did not hear any altercation or any problems?
No, I didn't.
So if there was an attack in the garage, you would have heard it?
I don't know. Quite possibly. I don't know.
You did not hear anything?
I didn't hear anything. And neither did our tenants in the cottage.
Something else I wanted to know is Nicola testified that you had an argument with Jill on the evening of the 21st. How did she know about that?
I think I probably told her at some stage.
When would you have told her?
No, it might have been her sister Kerry.
No, don't look at her, look at me.
No, I'm trying to think, milady. Her sister Kerry phoned that evening, and she might have told Nicola. I don't know, is the answer.
You can't recall you're telling her?
I honestly can't recall.
And you don't know if maybe Jill told her?
No, I'm pretty sure Jill didn't tell her unless she phoned her that morning.
Something else that I find strange is that you were looking for your wife, you thought she was missing, there were some issues between the two of us, you were frazzled from searching for your wife, but then you go to the office and you want to speak to somebody, or before you went even, you spoke to your friend there, you called him aside, you didn't want him to tell other people, you didn't tell the other people at the office that your wife was missing and that please could you spend the rest of the day looking for her?
No, I hadn't started looking when I had already started looking for her when I called him. I called him at about 12:30, only in case she had come to the plant. But as soon as I heard that Jill was missing and hadn't arrived at work, which was at about 9:45, I packed up and left the office, I think at about 10:15.
I'm just wondering, shouldn't you have told everybody that you're looking for your wife, she's missing?
Milady, at that point, I had just assumed Jill had broken down, or at worst, had had an accident on the way to work. It certainly wasn't something that I would then have put out to all of my colleagues at the plant.
Now, telling your Lodi friend, on 2 occasions that he should say something that basically presented you, as the press said, with an alibi, did you not think that would subvert the course of justice?
Not at all. I wasn't thinking about the course of justice when I phoned him at 12:30. I was simply thinking about where Jill might have been and what she might have been up to.
And when you sent him the email or an SMS when you already knew that she was missing and that she had been assaulted? Or
That was simply, as I explained, as a result of the media that had indicated that there was a suggestion of me calling a colleague at work for an alibi. And I just wanted to remind him about the conversation we had about me being at work.
But you wanted him to continue telling a lie.
No, but I needed him to be consistent, milady. That's all I was asking him.
But it is a lie.
It's a lie for Jill, yes.
Did you see pictures of yourself in the press or on videos or on Facebook?
Did I? Yes, I did.
Yes. Did you?
Yes.
Not recently. I'm talking about before you were arrested or at that stage.
No, even recently I do get to see them, yes. There's a newspaper downstairs with my picture on the front page.
Before you were identified by the 2 witnesses, or so-called identified,
I was in the newspaper, yes.
did you see them?
Yes, I did.
What newspaper do you read? The
Weekend,
Voice?
it was in the Weekend Argus, no. There was a picture of the family in the Weekend Argus on the Saturday, the 24th.
Then there was the statement that you made to the police that was Jay. When was it signed? When was it prepared and when was it signed?
On the morning of the 23rd, and it was signed at about midday.
So you made the statement on the 22nd?
No, on the 23rd.
On the 23rd?
Yes.
It was signed on the same day?
Correct.
There was testimony in court regarding an axe handle that was found in your garage amongst some items. Can you tell me about that?
There was testimony about that axe handle. I had forgotten about that axe completely. It must have been in the garage, broken for about 2 years. I hadn't seen it for some time. It was a short-handled axe that we used to chop logs with, but it wasn't something that we used.
Just the handle or an entire axe?
No, apparently the head was there too, but it had broken, the handle was broken.
I will call her Madam X, who testified. She said that initially when the two of you started a relationship, you told her that you had been separated.
I did tell her that, yes.
And was that correct?
No, that wasn't correct.
And that you were staying in a flat with one of your daughters?
That wasn't
Emma?
correct, no.
That was also not true. She also said that you discussed divorce on occasions, that you had told her that you'd seen a lawyer, spoke to a lawyer, seen a lawyer.
I did say I'd spoken to a lawyer, but we had at home, as I said, we had a copy of a draft divorce agreement that Jill and I had been looking at.
And on the 21st, you also discussed
No,
the possibility.
I don't think so. No.
There was testimony in court to the effect that when you sent her an SMS one morning at 2 a.m., that you say you cannot recall, that you said to her, this madness will soon be over and we will together. And then we will be together. Is that how you felt about the situation?
I was confused, milady. I think at that point in time, I felt that literally my heart had been torn out of my soul. I had lost my wife. I couldn't understand what had happened. And Miss X had been with me through that process. She knew what was going on at home. She understood the counseling process that we were working on. She herself unselfishly had said to me that her advice would be to give the counseling a full go to see how it turned out. So, that's the way it was.
How do you give counseling a full go if you see her at lunchtime and go for counseling at 5?
It was for a cup of coffee because she wanted to know how things were going. So the nature of the relationship had most definitely changed by that stage.
Thank you very much.
Thank you.
Any questions following the judge's questions or my questions, Ms. Galloway?
No questions, thank you, lady.
Mr. Webster?
Just a single question, or just very briefly, my lady. Mr. Packham, the court asked you about Exhibit J, which was the affidavit you deposed to on the 23rd of February before Mr. Sonnenberg.
Yes.
And the time given on that affidavit, if one has regard to Exhibit J, is 12:10 that it was signed.
Okay.
How long had you been interviewed before this statement was signed?
Since about 9:30.
And we see that Mr. Sonnenberg minuted 4 paragraphs essentially in 1 page of Exhibit J.
That's correct, yes.
Thank you. I have no further questions.
Thank you very much. Thank you, Mr. Packham. You may be excused. Yes, Mr. Webster.
Lady, may we ask for a 15-minute adjournment, just to consider 1 or 2 aspects?
Certainly. Certainly. Court will adjourn for 15 minutes.